Good morning, everyone. See, we've got some more people joining. Nice to see you. Good morning. Good morning. Okay. As I've just explained, we have had some technical issues at our end this morning. So my employment colleagues aren't here yet. They are hopefully going to be joining us. Everyone behind the scenes is trying to get them online. In the meantime, I'm afraid you're stuck with us. So I'm Gemma Duxbury and I'm a partner in the commercial public sector team, specialising in data protection, governance, procurement, anything public sector generally. I'm also joined by my lovely property colleagues, Sam Gorrell and Catherine Kennedy, who are, there's Sam waving. Good morning. And they'll be here as well to answer any questions that you might have with regards to property matters. And then I've also got my colleague, Sam, down in the corner that I can see there. Good morning, Sam.
Good morning.
How are you? Are you all right?
I'm good. How are you?
Good, good. A bit stressed this morning, Sam, for some reason. I wonder why. So if we're going to kickstart then, I think I'd received a couple of procurement questions, which I can start with because obviously we don't have anybody else really on the call. I think, Sam, you've had a question as well, haven't you? I don't know. Catherine, have you received any questions ahead of the webinar? No, lovely. So you can just sit and enjoy me rambling on then for the morning. Okay, so one of the first questions that we received was with regards to the new UK Procurement Act 2023. We actually received a few questions on this. Now, obviously, this was due to actually kickstart at the end of October, and that's now been pushed back to February 2025. And I think that schools and multi-academy trusts are now a bit concerned and a bit worried about how this is going to impact them and what effect that's going to have. So we have had a couple of questions. I'll try and break them up a little bit, just so I'm not chunnering on for hours and boring you to tears. So the first one that we had was just sort of, will it have an impact on schools and multi-academy trusts? And I think the answer is, like any legislation, pretty much, yes, it will. It is going to change the system and it is going to change it quite remarkably in certain circumstances. The whole idea behind the Procurement Act is to open up to smaller businesses, to increase competition, to make it fairer and more fairer playing field. It's to try and simplify the procurement process. That at the moment there's 5 or 6 different routes that you can use, and it's actually going to reduce them to 2, which on the face of it would sound like it's going to be simpler, but actually that's not necessarily the case, because even though there are only 2, one of those is effectively a build your own procurement sort of kit idea. So that's going to lead to complications in itself. It's also about focusing on making sure value for money. You're going to have a much more, you're going to need to have a much more strategic approach for making sure you've got value for money and that public benefit. As I've mentioned, it is going to be opening up to all sorts of suppliers. The idea behind the Procurement Act that this isn't just for the big boys, this is also going to be for the small and medium-sized enterprises. So you're going to be encouraged to engage more with suppliers. That's going to mean there's going to be a lot more transparent communication, and it's also going to increase, it will increase accountability, but there is going to be a lot more administration around that side of things and in procurement generally. And also training is going to be really, really important with regards to your staff. As I've said, in some ways, even though the process is being simplified, in other ways it isn't. So, for example, now they are introducing 16, and I repeat, 16 notices that are going to have to be issued as part of the procurement process. So it's a bit of swings and roundabouts. It's got good things, it's got bad things. And it is going to have an impact on schools because obviously if you're a multi-academy trust or a maintained school, you are classed as a public body. So we are going to talk a bit more about that. So I think that's the first bit I just wanted to say on the Procurement Act generally. To make sure that you are aware that it is going to have an impact, and I'll have a bit more of a chat about it later on. Hi, Suzanne. Luckily, Suzanne has been able to join us finally.
Hi,
good morning.
Few technical issues, but
I know. I was just telling everybody, I was like, oh, good Lord. And I didn't even know Ruth wasn't here either. So anyway, good morning. It's lovely to see you. Thank you so much for joining us. I'm hoping Laura is also going to be joining at some point, but we'll have to see how that goes. At least we've got you. At least we've got you.
Yeah, it's a start.
It is, it is. So Suzanne is one of our lovely employment colleagues and she'll be dealing hopefully with a question with you shortly. So Sam, if I could pass over to you for you to chat through your question and your response to it, that would be super.
Yeah, of course. Thank you, Gemma. Yeah, so the question I've had is, what are the best methods for handling non-payment of school fees by parents? So this applies obviously to private schools. And of course, the issue of non-payment can be sensitive and challenging, but with the right approach, it can be addressed effectively, but also fairly. Now, this right approach is derived from having the correct processes and procedures. First and foremost, communication is key. So establishing clear and open lines of communication with parents is very important. Families will need to be aware of need to be made aware of their financial obligations as well as deadlines for payments. And this can be achieved through regular reminders and transparent communication channels, whether that be emails, newsletters, and parent-teacher meetings. It's also important to have a dedicated point of contact within the school who can address any questions or concerns parents may have regarding their fees. So parents know who to come and speak to about the matter and make it easier for them in terms of maintaining that open line of communication. Another thing to consider in terms of the processes and procedures is it's vital to be proactive. Now, rather than waiting for a payment to become overdue, you should implement a system for monitoring and tracking payments. Now, as I said, this could involve sending reminders before the due date, as well as following up promptly when payment is missed. So it's important to keep on top of this. And of course, by taking this proactive approach, you can often prevent small issues and small missed payments escalating into larger problems. Flexibility can also be significant in terms of managing non-payment. So for these parents, life can be unpredictable and something unforeseen may arise, which may cause unexpected financial hardships. Offering flexible payment plans or temporary deferment options can help families navigate these challenges without feeling overwhelmed. And it not only demonstrates empathy and understanding, but also increases the likelihood of eventually receiving the outstanding payments. In cases where non-payment persists then and you have these procedures in place, it's important to engage with the parents directly as well as empathetically. Arranging a meeting to discuss the situation and explore possible solutions together can lead to a successful outcome. As I say, this conversation should be approached with sensitivity and it should be solely focused on finding a resolution that benefits both yourselves and the parents. The goal is to work in collaboration with the parents and address the issue and not to create further tension or conflict, which exacerbates the problem and, of course, results in you not being paid the outstanding fees. Another critical thing to consider in terms of these processes and procedures is documentation. So keep detailed records of all communications, agreements, and payment histories in order to manage the situation. These records provide a clear timeline of events and can ultimately be evidence if the situation escalates to a point where legal action is necessary. And coming on to that final point about legal action, this should always be a last resort. So the processes and procedures I've set out should be carried out in the first instance. However, if you've exhausted all those options and you still aren't getting anywhere, then we can obviously provide legal action and legal advice. We can also provide valuable guidance on the most appropriate course of action at that juncture to help ensure that any steps that are taken are compliant with the correct protocols. So in conclusion, handling non-payment of school fees requires a delicate balance of empathy, proactivity, and firmness. And if you need any help or guidance at all or any advice with regards to these procedures that you have in place, I'd be happy to have a chat with you about your processes. Thank you.
Thanks, Sam. That was really interesting. It's always a tricky one, I think, with regards to payment, particularly the times that we're living in. I think everyone's having a really difficult time with these things. So I think having that discussion is really, really important at the moment. I'm now going to move on to, I think we had an employment question, which Laura finally joined us. Nice to see you. How are you?
I'm good, thank you. Yeah, sorry about that. Some
Don't
technical
worry.
issues, but I'm here now.
I think everybody's had them this morning. Don't worry. I think we've had one of those mornings, unfortunately. It's lovely of you to join us. We did receive a question in prior to. I didn't know who was going to be dealing that, if it was Laura and Suzanne or one or the other, with regards to the question that we've received so far. So we received in a question from someone that said that they're kind of new to the education sector and they're working at a college and they have received a flexible working request to begin from January 2026 after maternity leave. And at the moment, it seems the manager wants to decline that as they don't know the student numbers, etc., at this stage for 2026. How would you advise that they respond? And would others just accept that request? I will now hand over to you and leave it in your capable hands.
Thanks, Gemma. I think we are going to touch upon flexible working in terms of the employment bill and potential changes or not the changes that we expected actually in relation to that, which I know Suzanne's going to talk a little bit about. But in terms of that request, I think one of the key points there is what has been identified actually in the person asking the question is that they don't necessarily have the information at this stage to either grant that request or to refuse it. And I would say that, obviously, there are a number of potential grounds on which an employer can say no to a flexible working request. The right to work flexibly is really a right to ask for it. It's not necessarily a right simply to have it. And I know there's been quite a lot in the press about changes to that, but ultimately that's about allowing someone to make the request sooner than they used to have to previously wait a certain amount of time. So they can make that request, but there are still a number of reasons which an employer can rely upon to say no. And essentially they're about, the effect of the running of the business or the service, or in this case, the running of the college, and potentially it could be to do with student numbers, for example. So if they haven't yet got that information, to me, it would seem sensible that they say to the employee, we can't yet make the call on this. And I don't necessarily think other colleges or other schools would necessarily just say yes because a request has already been put in. But Suzanne, is there anything you want to add to that just from recent change or potential changes about flexible working?
No, I agree. How the changes are going to work. So at the moment, the right to request is you go through the process and you have your set reasons where you can reject. It's not changing what those reasons are, but it's changing the emphasis from a right to request to basically a right to refuse on reasons only. So not only just one of those permitted reasons, but also to explain within that what that reason actually is in practice. Now, we've not got any detail on what that will actually look like in terms of what the detail of that process, any changes will be, but it still does show that it can be refused. You've just got to have a good reason to refuse. And I'm with Laura. I agree that where you can't possibly know timetables and pupil numbers and things like that, at this stage, that would be a reasonable reason. And so what you can do is, let them know that they can make it closer to the time. And then have a look at it then, would be my view.
Lovely, thank you. Laura, did you mention that you wanted, you and Suzanne were going to talk about all the flurry of activity in the last week or so? I know that there was WhatsApp messages and Teams messages flying around in the middle of the night after all the announcements.
I know it was like election night for us, people staying up late. I think we'll touch on it briefly. I know the next Q&A in November is going to be dedicated, or there's going to be part of the session dedicated to that, because there may be more information. Obviously, it only came out at the end of very end of last week. So yeah, we did spend a bit of time Friday and over the weekend, just looking at what's come out of the bill, because potentially this is a huge change in terms of employment law. The biggest change, for decades is what the commentary around this is saying. And it was the last day possible for the government to put the bill forwards, because they said they would do that within the first 100 days. So it was the last day they could do that in terms of when Parliament sits, for example. It's a huge document. There's a lot in there. So what I will say is that much of it we are waiting for further information or further consultation periods, because the government have made clear that quite a lot of it is going to be subject to consultation with employers before things are actually put into place to change the law as it currently stands. And some of the legislation that will need to come in, we're talking about next year into 2026. So for example, with unfair dismissal, obviously this is one of the big ones. So at the moment, to bring a claim of straightforward or what we call ordinary unfair dismissal, an employee has to have 2 years continuous service. So what the employment bill says is that potentially that's going to become actually a day one right. So they're talking about getting rid of the section of the Employment Rights Act that says you have to be there for 2 years, removing that. But then we're not sure exactly what will replace it. There is in the bill talk of making it a day one right, so that an employer, will have to justify any dismissal from day one, apart from in certain exceptions, which may be to do with a probationary period. So what the government are saying is essentially, although it's maybe going to be a day one right, they look like they might be building in some kind of probationary period. There's talk of 6 months, there's talk of 9 months, we don't know yet. But during that period, it may be that an employer can actually dismiss someone without them being able to challenge it as an ordinary unfair dismissal, but we don't know yet essentially what that will look like. But that is obviously a big thing. And for us, we're aware that the strain that might put on employers, because, sometimes it does take quite a bit of time for somebody to know whether or not the person they've hired in a particular role is right. And having that 2-year, period of time to almost assess the situation is obviously very helpful to a number of employers. Now, they obviously can't act unfairly in relation to those people. There's always been day one rights in terms of discrimination. But if this unfair dismissal changes to day one, which it looks like it is going to, it's just how that's going to be implemented. It's very big. But we've got quite a bit of time. They've said that one in particular is unlikely to come into play until autumn 2026. So we're talking another 2 years, for people to get the processes in place and to understand how that works. So I think there's a lot of time for that one, which is good news. But yeah, there's a couple more that we can pull out the key things. So I'll hand over to Suzanne to talk about a couple, then I'll come back and just mention fire and rehire and 0 hours and what the bill says about those at the moment.
Thanks, Laura. So we've touched on the changes proposed to flexible work and how the scope of that is going to change in terms of the starting point. There's also proposals to change some of the family-friendly rights. So in the case of parental leave and paternity leave, to get rid of the qualifying period before you can take those kinds of leave, so they become a day one right. And then in regards to bereavement leave, at the moment we have statutory right for parental bereavement leave. And what we expect to happen is that's going to be replaced with a wider bereavement leave entitlement, which will be specified in future regulations. If anyone was on the session last month, I spoke about sexual harassment and the new laws that are coming in on the 26th of this month. The government is proposing tweaking those, so it won't change what's coming into force on the 26th of October this year, but there are going to be future changes. So if anyone remembers, one of the things we spoke about was it's a requirement to take reasonable steps to prevent sexual harassment. And that had changed from when the previous bill was first put out, which was to make it all reasonable steps. Well, they're looking to bring back the all, which obviously is a higher bar on employers. They're also going to specifically bring in third-party harassment, because as we spoke about, it's there through the back door at the moment in terms of how the Act's worded, but they're going to specifically bring that in, which again was something that was previously discussed in Parliament and didn't make it through the final hurdle, but they're bringing that back. And also when looking at protected disclosures, they're also going to increase that protection for whistleblowers to include those who've complained about sexual harassment. So again, it's just increasing the amount of regulation in this area to make it clear that employers have got to take the duty to protect their staff seriously. And then we also have, in terms of specific to schools, they are proposing to bring in the school support staff negotiating body, which I think is, as you guess, it's to do what it says on the tin, which will give that negotiating body the remit for support staff to negotiate on their behalf in regards to terms and conditions of employment of those staff, training for them and career progression. And it will allow the Secretary of State to refer matters to the negotiating body for consideration, or the body may consider a matter within its remit without it being referred. So they will have quite a bit of power. And it's not just in regards to LA schools, that would also seem to us to apply, or that the intention is it would also be seeking to include those who fall within academies and are employed under a support staff contract of employment. Again, there is likely to be more detail come through on that, but that is what we're expecting as a starting point. Which kind of leads on to trade unions generally, and perhaps what we were all expecting, which is the new government is rolling back a lot of the restrictions that were being placed on trade unions by the previous governments. So, for instance, there is going to be an obligation on all employers to give their workers a written statement that they have the right to, that confirms that they have the right to join a trade union. And that statement will be given at the same time as you're giving out your contracts of employment Section 1 statements. For schools, I doubt that will be such a big concern, given how unionised your employers are anyway, but that's going to be the starting point. There's also going to be changes to the conditions for trade union recognition. So where the previous government brought in some limits and percentages required for recognition, we're expecting that those are going to be removed. So the current requirements to show at the application stage that at least 50% of workers in the bargaining unit are likely to support recognition will be removed. And there'll also be a power for the Secretary of State to reduce the requirement to show at the application stage that at least 10% of workers in the bargaining unit are members of the trade union. So obviously that's a significant reduction. In addition, for the final ballot, if the majority of the workers voting support recognition, that's going to be sufficient for recognition, and the unions will be entitled to conduct collective bargaining then on behalf of the bargaining unit. In terms of time off to provide trade union time off provided to trade union reps, it's the case that an employer that permits an employee to take time off for carrying out trade union duties must, when requested by the employee, provide them with accommodation and other facilities for carrying out those duties or undergoing the training for which they need to take the time off, although that must be reasonable in the circumstances. In those cases, an employee may present a complaint to an ET that an employer has failed to permit the employee to take time off or to provide them with those facilities. And the employer would need to demonstrate that the time off requested was unreasonable. Similarly, for the trade union equality representative, what we will have is that an employer must permit an employee who's a member of a trade union recognised by the employer and an equality representative of that union to take time off during the employee's working hours for the purposes of carrying out activities for the purpose of promoting the value of equality in the workplace, arranging learning or training on matters relating to equality, providing information, providing advice or support to qualifying members of the union on matters of equality, and consulting with the employers on matters relating to equality in the workplace, and obtaining and analysing information. And those provisions will only apply where the trade union has given the employer notice that the employee is an equality representative of the union and the training condition is met. So that's another bit to be aware of. And then in regards to, obviously the previous government brought in provisions about minimum service levels, and Labour is committed to getting rid of that. They see that as anti-strike legislation. So they are, unsurprisingly, going to repeal that section. In terms of industrial action ballots, they're also going to simplify that and ensure that workers have protection from detriment for participating in lawful strike action. And there's going to be some further consultation on what type of detriment should be prohibited. And then there's also going to be a new Fair Work agency that's going to be established, which will deal with the enforcement of the national minimum wage, holiday pay, SSP, and some other aspects of modern slavery. So what we can see is perhaps what we expected is that Labour is more union friendly. They are going to make life easier for the unions, which is going to make it more difficult. Schools already are already one of the areas where we do see strike action, and so there is a risk that that will be increased. And I think then if I hand back over to Laura, but just what I would say is none of that is immediate. We are still waiting for some of the detail and dates when they will become effective.
Thanks, Suzanne. Yeah, like I say, that seems to be the theme, is that a lot of change on the horizon, but we just have to wait for the further detail and for implementation dates. But just two more just to flag up, which I think are quite significant. One of the key features of the bill is around fire and rehire processes which the government wants to target. So at the moment, if an employer wants to make changes to somebody's contract of employment, and they can't get agreement from that employee, because agreement would always be the preferred route, there is an option, and it is only used in quite exceptional circumstances, but at the moment an employer can essentially bring a contract of employment to an end. It has to have a substantial reason to do that, but then essentially offer to re-engage the individual at the same time, but on a new contract with the new term within it. So it's known as fire and rehire. It's been in the press quite recently about being criticised, and so the government have made it clear that they want to try and minimise, if not completely get rid of that process for employers. So it is quite a significant change, because unfortunately it does sometimes need to be relied upon. And the way in which the bill suggests that they're going to do that is to create a new category of automatic unfair dismissal. Again, that would be a huge change. We do have a number of prescribed automatic unfair dismissal protections. If this was a new one, again, it would be a day one right, especially given what I just said about the change to that in any event. But essentially it would be that the dismissal would be unfair if the main reason essentially was that the employer had sought and then the employee had refused the variation to the contract of employment. And a dismissal will also be unfair if the employer replaces the employee with another person carrying out substantially the same duties who is willing to accept the varied term. So that again is a potentially significant change. Now, the bill does suggest there will be some exceptional circumstances in which an employer will be able to either defend that kind of claim, or the employee won't be able to bring it in the first place. And that's where the employer would have to show that essentially the reason for needing to make the change is really to get rid of or reduce or eliminate financial difficulties at the time of the dismissal. But it's going to be a high threshold. The bill talks about the employer at that time saying that it has to do that to show that it can carry on the business as a going concern. And that kind of language suggests we're almost in the realm of nearing insolvency or liquidation. So it is going to be a high threshold for when an employer can potentially carry on using fire and rehire as a potential process. So again, something that we'll wait for further information on. Linked to that slightly, because sometimes fire and rehire is used as an alternative to redundancies, but collective redundancies, at the moment, there are certain triggers for when an employer has to consult with a group of people, whether that be the trade union reps or direct, and also notify the Secretary of State if it's making a number of redundancies within a period of time. So if it's making more than 20 people redundant in a 90-day period, then there are these triggers for having to collectively consult, not just consult with individuals. Now, at the moment, the law says that those 20 or larger numbers for further triggers and for more onerous obligations relate to one establishment. And there was a historic case about stores, Woolworths stores, for those who remember Woolworths, and whether, that meant per store or the whole of Woolworths. And so recently we've been working on the basis that it, means per individual establishment. But what the bill says is that it wants to expand that scope of obligations relating to collective redundancies, and about notifying the Secretary of State if you're going to make redundancies, and to say that it is actually the employer rather than the single establishments. So in an education setting, it might be that some people are already using this approach, but it could be for multi-academy trusts that it's going to be per school rather than as an employer as the whole. They'll have to look at individual establishments. So those obligations to collectively consult might be triggered earlier than we have at the moment. And just the last one I'll mention is potential changes to 0 hours contracts, which the government is keen to, again, try and minimise, if not, almost get rid of. But it seems that what they're doing is introducing quite a lot of rights for people who are going to be on what we call 0 hours, or they refer to low hours contracts. Now, they haven't defined them, so we don't know what low hours contracts will mean. But essentially, it's going to be people who don't necessarily have set hours, who work casual hours as and when for an employer. And what the bill suggests is that those people will have a right to be offered a permanent contract solidifying those hours. They don't have to accept it, but it suggests that the employer has to offer the individuals a permanent contract after a particular reference period. Again, we don't know what that is, but say it was going to be a 12-week period, then the employer would have to look at what hours that casual worker has actually done for them over 12 weeks and then offer them a permanent contract, putting those into place and saying, do you want to have a contract which gives you these as a minimum? You could see then an employee almost potentially having a period of time where they've packed in a lot of hours, and then they can turn around and say, I've got a right to be given those now going forwards for every period, which is potentially problematic for employers who only need people for certain parts of the year. So for example, exam invigilators might be on those kind of casual 0 hours contracts. So again, something to await further detail on, and it potentially is a change for those individuals who will have more rights than we see them have currently. So they're just some headlines. I know we've spoken for quite a while, but there is quite a lot more detail, and we can expand on that in the next Q&A if we have a dedicated session to that. And I encourage people to have a look at any press releases they've seen about it, any articles, and if there's anything in particular that they're not sure what the bill means in relation to certain changes with employment law, then drop us a question ahead of next session and we'll be able to answer that for you.
Thank you, ladies. Yeah, I mean, even I was sort of swept up in it all the chat and everything about it. It's quite interesting. And it was funny because I was at my kids' dance classes at the weekend, and even just sat in the cafe listening to people around me, there was a lot of people that have small businesses, and they're really panicking about all of these things and how they're going to impact them, and if they're even going to be able to continue in business because of it. And there was also people there that was sort of saying, well, okay, the idea of getting rid of 0 contract hours is great and everything to protect people, but actually a lot of people want 0 contracts, 0 hour contracts. So it's one of those, isn't it? It's a really hot topic at the moment, and I think it'd be absolutely worthwhile making sure that we do a dedicated session for that, because I think the last thing I looked at, was it 28 things that have been, something like that, I think was the latest. See, I do read your messages. So I think I think it's, you know, it is a bit of a minefield, really. And hopefully, though, like you say, it's not going to be quite as scary as it initially seems. We'll just have to see over time, won't we? We'll just have to see. But obviously, it's going to be a huge impact. Right. I don't know if we have any other questions. If anyone's got any questions that they'd like to ask, if you want to raise them in the relevant boxes. I'm having a look. I can't see that we've got anything in the Q&A at the moment. I slightly touched on the Procurement Act before. I hope that answered. Luckily, poor Suzanne and Laura, you missed that. I bet you're devastated. Just to give you a, you know, if I didn't answer your question, or if you'd like more information, please do let me know. Don't worry, because nearer the time, we will be doing probably a dedicated session on procurement, or at least we'll be doing some training on it. I would like to draw your attention, though, to the fact that the government have done what they call knowledge drops, which are on the gov.uk website, DFE I think it is. So they have these short snappy videos which really don't tell you a lot, but if you'd like to go and look at them, those are where they're pointing people at the moment. But as it speeds up nearer the time, we will be reporting to you on that, and we will be able to give some training on that specifically. So just having a look, I don't think we've had any more questions. If anybody can anybody see anything that I can't? Or okay, so hopefully that's been an interesting session for you. Obviously we've covered a few things there. If you do have any questions, you know, you don't have to wait for these Q&As. Please always just pick up the phone or drop us an email. We're always available. You can go on our website to find our details, and if you have any questions at all, we're always here. Ruth will hopefully be back next time, so you won't have me not realizing I'm chairing but chairing, and we'll have less technical issues. So happy days all round. Wishing you all a lovely day, and hope you have a fantastic half term, because I'm sure that's coming up, and that you at least get a little bit of a break. Thanks to all my colleagues for joining, really appreciate it. I know it's been traumatic, and thank you all of you for coming and listening to us and having these sessions with us. We really do enjoy them. So take care, and we'll hopefully see you again shortly. Bye everybody, take care.
Bye.
Thank you, everyone.
Bye.